LAP basically seeks to do is we are democratizing information about judges through our centralized clerkships database, a repository of post-clerkship surveys with a variety of information students need to know before clerking. Mistreatment is definitely something we seek to capture in a way law schools troublingly have been unwilling to ask about, but there's other stuff you'd want to know before clerking. How the judge provides feedback, whether you get writing and courtroom experience, how many co-clerks you'll have, whether you can take vacation, like all kinds of normal stuff you might want to know, stuff you'd get to know if you pursued other private or public sector employment.
Welcome to On Record PR, where we go on record with industry leaders to discuss best practices for public relations strategies that drive business success. Let's get started with the show.
Welcome to On Record PR. I'm guest host Leslie Richards. Today, I'm going on record with Aliza Shatzman, who is an attorney and advocate for judicial accountability. Aliza is the president and founder of the Legal Accountability Project, a nonprofit aimed at ensuring that law clerks have positive clerkship experiences and extending support and resources to those who do not. Aliza earned her BA from Williams College and her JD from Washington University School of Law. After law school, Aliza clerked in the DC Superior Court during the 2019-2020 term. In March 2022, Aliza submitted written testimony for a House Judiciary Subcommittee hearing about the lack of workplace protections in the federal judiciary, detailing her personal experience with harassment and retaliation by a former DC judge in order to advocate for the Judiciary Accountability Act, legislation that would extend Title VII protections to judiciary employees, including law clerks. Aliza now writes and speaks regularly about judicial accountability and clerkships. She's been published in numerous law journals and other forums. Welcome, Aliza.
Thank you.
It's great to have you on the podcast. Why don't we start by you just telling us a little bit about the Legal Accountability Project, its goals, major initiatives, and why the focus on law schools as partners? It's kind of a three-part question.
Yeah. The Legal Accountability Project basically seeks to ensure that law clerks have a positive clerkship experience and then extend support and resources to the ones who don't. I began advocating for judicial accountability because of my personal experience with gender discrimination, harassment, and retaliation during and after my DC Superior Court clerkship, which I first shared publicly in written testimony last March for a House Judiciary Subcommittee hearing about workplace protections in the federal judiciary. And we work on several major initiatives in collaboration with law schools aimed at increasing transparency in the clerkship application process, an issue that leads too many new attorneys each year to unwittingly enter unsafe or unsupportive work environments because they lack information about judges, and really also addresses the lack of judicial accountability for both state and federal judges who mistreat their clerks. I really think of the nonprofit as the resource I wish existed as a WashU law student applying for a clerkship, a law clerk experiencing mistreatment and unsure where to go for help, and a former clerk engaging in the formal judicial complaint process. Our initiatives are premised on this basic set of facts. I speak with a lot of law students, and I'll typically say, so you want a clerk? Fantastic. Encourage you to clerk. How would you avoid judges who harass their clerks? Some students say they'd ask somebody. Who are they going to ask? Law school administrators, clerkship directors, deans of career services tell students to, quote, do their research about judges before applying. But really, what research are they going to do when no information about judges who mistreat their clerks is available to students? A handful of law schools conduct a post-clerkship survey of their law clerk alumni. Some, but not all, keep those in searchable databases for students, alums, and including alums who were judges to look at. They understand that these do not capture the scope of the problem because law clerks who've experienced mistreatment are notoriously unwilling to report that back to their law schools, fearing reputational harm in the legal community for saying something less than glowing about a judge, as well as fear of retaliation by the judges who mistreated them. And unfortunately, the tone of some of these post-clerkship surveys that law schools currently send out is really, you had a positive clerkship experience, right?
Yeah.
What I say to law schools is that no law school has a monopoly on information about judges. Nobody knows about all the judges. But every school has a ceiling on the number of judges they can keep track of. And this totally depends on who alums have clerked for in the past and their willingness to report back on their experiences. As we've discussed, law clerks who had a negative experience don't report back. So administrators who are advising students on clerkships have information that is incomplete at best. So what LAP basically seeks to do is we are democratizing information about judges through our centralized clerkships database, a repository of post-clerkship surveys with a variety of information students need to know before clerking. Mistreatment is definitely something we seek to capture in a way law schools troublingly have been unwilling to ask about.
Reluctant.
But there's other stuff you'd want to know before clerking. How the judge provides feedback, whether you get writing and courtroom experience, how many co-clerks you'll have, whether you can take vacation, like all kinds of normal stuff you might want to know. Stuff you'd get to know if you pursued other private or public sector employment. So we are asking law schools to send our post-clerkship survey via email to their law clerk alumni. They will create an account with us. They'll go through several security and verification steps. They'll review our terms of service, our privacy policy. Once they've created an account, they can report anonymously on their clerkship if they choose. And we think law clerks who've experienced mistreatment will report anonymously. This mechanism vastly expands the candor and breadth of responses and the amount of information students are going to have access to as they're applying for clerkships, as well as the info that clerkship directors and deans are going to have to advise students on clerkships. It is a subscription model, so law schools will pay $5 per student per year based on total JD enrollment, which is a very small sum considering the number of students whose, lives and careers they can protect by doing this. And then in exchange, when the database goes live, students are going to get access to reading the reports. But so importantly, why this is better than anything a law school could ever do internally. Students don't just read their alums reports, which is the current system. They can read the reports of all the alums at all the schools participating in this database. This is based on my personal experience, my conversations with more than 70 law schools worth of deans and clerkship directors, and more conversations with law clerks and students than I can count. The best way on the front end to ensure positive clerkship experiences and to diversify the clerkship applicant pool and pipeline, because it is disproportionately historically marginalized groups, women, non-white, first-gen, LGBTQ students, who disproportionately lack access to information about judges through formal networks and information channels that are helping some of their peers obtain clerkships. That's basically what we're doing. In conjunction with it, I do a lot of law school programming. So I visited more than 20 law schools this year, sharing my experience, talking about the scope of the problem, talking about solutions, including LAP's resources, which are really going to transform not only the clerkship application process, but the legal profession for the next generation of attorneys. And it's really, for me, about empowering students to demand safer workplaces, increased equity and transparency in the process, and also to inspire current and former clerks who've experienced mistreatment to finally share that less than positive experience in a way they have historically not done.
Sounds amazing. It sounds like you've identified a place in the system that has been sort of a black box, and you're bringing transparency and light to it. And it sounds like important work that really does address some of the bigger issues in legal around diversity, equity, and inclusion. This kind of starts at the very beginning of that journey. And as you said, sort of starts to democratize it a little bit, which I think is really interesting.
Law schools have conveyed that clerkships are their express purview. They have for a long time resisted efforts at standardization and transparency. Every school does things a little bit differently. Some schools have very robust resources, multiple career services professionals dedicated to this, lots of programming. Some schools have fewer resources, And it's really not a statement about their rankings. They're not super related as to how many clerks a school is sending and what the resources look like. So law schools, clerkships are their express purview. I think that makes them the ideal vector for change on this issue. Unfortunately, law schools don't love me saying this, but that's okay. Some of them have historically been part of the problem. Sending students into clerkships they know or suspect are less than positive in order to increase their clerkship numbers, bolster public perception of the schools. And I don't think it is mean-spirited. It is more that there is a uniformly positive messaging around clerkships on these law school campuses, but it goes a step further. Several of our professor moderators at LAP's events said things to me privately afterward and also publicly to the groups of students, basically saying, we encourage people to accept a clerkship even if they know it's going to be taxing or difficult because the experience is worth it. And they say, that's what I did and it was beneficial. I really, really worry about that messaging and framing. And several of those professors followed up with me after the event to basically say, I am preparing students, especially historically marginalized groups, particularly women, for the legal profession that is.
Oh my goodness.
Well, my response, respectfully, is that my goal is to prepare law students and empower them to demand the legal profession that should be. And one of the biggest boulders I push up the hill is I'm talking about the messaging around clerkships, changing the culture in the legal community. Nobody should willingly accept a taxing clerkship experience. You should not have to do that. And there is no guarantee that if you experience mistreatment, as my experience illustrates, that will stop when the clerkship ends. Judges, particularly life-tenured federal judges, have enormous far-reaching power over their former clerks' lives, careers, and reputations. So law schools historically been kind of part of the problem, but I definitely think they can and should be part of the solution. And I feel that every law school can and should be an ally.
And I think the other thing that's really interesting in that statement, Aliza, is the definition of taxing.
Yes.
Can be very varied. There's something that's different. Framing it as something that's taxing almost says, we're all expected to work hard. Well, that can be taxing. That's very different than something that gets at your core sort of personhood, a demonstration of respect for you professionally.
The response has overall been quite positive, particularly from the judiciary. I spend a lot of time speaking with both state and federal judges who are generally very supportive, and I appreciate that many have been willing to reach out to their alma maters and schools from which they hire to convey support, encourage those schools to partner with the Legal Accountability Project. Mm-hmm. They understand a couple things. They understand that transparency benefits both law students and judges, helps everybody identify a good fit. Because not every student is a good fit with every judge. Sure. Personalities, clash. That's not necessarily mistreatment, but that does not help anybody.
Right.
So judges understand that. And why not on the front end help everybody identify a positive experience? Judges also understand that this initiative is going to increase diversity in their clerkship applicant pools, clerkship pipeline, and then larger change in the legal profession in terms of diversifying the face of the profession, including who rises to and through the judiciary. Judges convey to me, and this is in line with the limited data that exists about diversity in law clerk hiring, their applicant pools are overwhelmingly white and they are overwhelmingly male. It is historically marginalized groups who disproportionately lack access to the information they need in order to feel empowered to apply for a clerkship. And these students want to know that judges hire diverse candidates and are sensitive to diverse identities. Judges need to be a little intentional in their hiring in order to diversify their clerkship hires, but they appreciate outside efforts to assist. Judges also know that this type of internal database and post-clerkship survey already exists at a handful of law schools. They went to many of the law schools that conduct these post-clerkship surveys. They perceive there to be negative survey responses in there, and they perceive that law schools are warning students to avoid certain judges. They absolutely overestimate both of those things, but it's interesting that they are aware and okay with that. I mean, besides a couple of judges making really ridiculous statements recently about law clerk moratoria on hiring, we really don't see judges saying, I'm not going to hire from the T5 because this school has an internal database. They're just not, because those are excellent candidates and they are fortunate to go to well-resourced schools. Well, whether you go to a well-resourced school or a less well-resourced school, there shouldn't be a horse race for the basic truth about clerkships, the basic truth about judges as managers. So response from the judiciary has been quite positive. Law schools, I'm interfacing productively with many of them. We definitely faced a first mover problem in terms of getting law schools on board. That's okay. This is a long-term process, and I appreciate the many deans and clerkship directors with whom I work very productively. Mm-hmm. There are a handful that say things to me like, we're blessed to work with only good judges and all our alums have a positive clerkship experience. My alma mater has told me it is our official policy that we don't warn students about judges who harass their clerks. One said to me, it's not harassment, it's just women adjusting to their first jobs. And then there's one clerkship director who just refuses to speak with me after a year of advocacy and outreach in conjunction with students and professors. Wow. That's the minority, and we think we will get them on board eventually. I think some law school administrators perceive me to be criticizing them. I don't mean to. I mean to criticize the system and really encourage everybody to be part of the solution. A couple law school clerkship directors are quite entrenched, and that entrenchment benefits them, but it certainly does not benefit their students and alums who continue to have negative experiences. Sure. And either tell their law school and it falls on deaf ears, or they do not tell their law school because they perceive that the response will be negative. So they tell me instead. So that's kind of the response. It's been interesting. Every law school is different. They have their own unique idiosyncrasies, but that's okay. I spend a lot of time thinking through the strategy for every school, every dean and clerkship director in conjunction with student orgs and alums.
Wow. It's a tremendous project. Thanks so much, Aliza. Let's take a quick break for a message from our sponsor, and we'll be right back.
This episode is brought to you by Furia Rubel Communications. Recognized as the #1 agency by the National Law Journal, Furia Rubel helps top businesses and law firms with high-stakes public relations and marketing, reputation management, crisis planning, and incident response, including high-profile litigation media relations. To learn more, go to furiarubel.com or email podcast@furiarubel.com.
If we could circle back to the experience that led you to all of this work, this very important work, that I think might help us understand how you came to this. And it's, so many of us have experiences that we interpret or perceive as extremely personal, but I think what you're bringing to light is that this is not something that is unique, right? This is something that many people have experienced, and there's some universality to it, which makes it more powerful.
That's correct. And I share my experience a lot, and I think it's important because I try to convey to everybody that my experience is not rare, but it is one that is rarely shared publicly due to the culture of silence and fear that the legal community has created around the judiciary, and larger cultural, encouragement of silence around workplace mistreatment. So I decided to clerk in DC Superior Court during the 2019 to 2020 term because I aspired to be a homicide prosecutor in the DC U.S. Attorney's Office. And I knew that DC AUSAs, DC prosecutors, appeared before DC Superior Court judges. I hope to get a crash course in trial lawyering, judicial decision-making. I went to WashU Law, and the messaging around clerkships at my law school, like at every law school, was uniformly positive. I was told that I would develop a lifelong mentor-mentee relationship with the judge for whom I clerked, that the position would confer only professional benefits. I was applying for clerkships in 2017 and 2018, and at the time, I don't remember anybody talking about the potential downsides of clerking, the enormous power disparities between judges and clerks, the fact that judges are exempt from Title VII of the Civil Rights Act, the fact that these are enormously isolated work environments. that judges can exert far-reaching power over their former clerks' lives, careers, and reputations. I was told to apply broadly, meaning across the US, across the political spectrum, and to accept the first clerkship I was offered. So I did all those things. I took my 4 DOJ internships worth of experience, I packed up, and I moved to DC, intending to launch my career as a homicide prosecutor. Unfortunately, that did not happen. Beginning just weeks into this clerkship in late August, early September 2019, the judge for whom I clerked began to harass me and discriminate against me because of my gender. He would kick me out of the courtroom and tell me that I made him uncomfortable and that he just felt more comfortable with my male co-clerk. He told me I was bossy, aggressive, that I had personality issues. The day I found out I'd passed the DC bar exam, so big day in any young attorney's life, he called me into his chambers, got in my face, and said, "You're bossy." And I know bossy because my wife is bossy. I was just, devastated. This was my first job out of law school. This judge was clearly singling me out for mistreatment. I remember crying on the walk to work in the morning, crying myself to sleep at night. I just wanted to be reassigned to a different judge for the remainder of the clerkship, which was supposed to last a year. My workplace in the DC courts did not have an employee dispute resolution or EDR plan in place that might have enabled me to be reassigned. And I knew that I needed a full year of work experience to be eligible for my dream job at the DC U.S. Attorney's Office, which was the reason I'd accepted this clerkship. I confided in some attorney mentors who advised me to stick it out, and so I tried. We eventually transitioned to remote work during the pandemic. March 2020, I moved back to Philadelphia to stay with my parents and worked remotely. And the judge basically ignored me for 6 weeks. Calls, texts, emails went unanswered. He communicated with me exclusively through my male co-clerk. And then he called me up in late April 2020, told me that he was ending my clerkship early because I made him uncomfortable and lacked respect for him, but he didn't want to get into it. And then he hung up on me. So I called DC Courts HR. They told me there was nothing they could do because HR doesn't regulate judges, that judges and law clerks have a unique relationship. Then they asked me whether I knew that I was an at-will employee. So then I reached out to my law school, to WashU Law, seeking advice and support. And I found out this judge had a history of harassing his clerks, that law school administrators, including the clerkships director and several professors, knew about at the time I accepted the clerkship, decided to withhold that information from me because they wanted another student to clerk. It took me about a year to get back on my feet. I did draft a formal judicial complaint connected with some DC judges who directed me to the local Judicial Conduct Commission. I decided to wait to file it until I had a new job because I was already worried this judge would retaliate against me. And the judge had told me in our last conversation that if contacted, he would provide a neutral reference. So it takes me about a year to get back on my feet. I secure my dream job in the DC U.S. Attorney's Office, move back to DC in the summer of 2021, intending to put this behind me, launch my career as a prosecutor. And if I had stayed in that job, who knows where my career path would have taken me. But I received some pretty devastating news 2 weeks into training that altered the course of my life. I was told the judge had made negative statements about me during my background investigation, that I wouldn't be able to obtain a security clearance, and that my job offer was being revoked. I remember crying on the phone with USAO leadership, crying on the phone with DC courts leadership. The USAO wouldn't tell me what had been said about me. They would not give me the opportunity to challenge the negative reference. They said the decision was final. A couple days later, they reached out, invited me to interview for another job with the office. And then they revoked that offer too, based on this judge's same negative reference. I was 2 years into my legal career. This judge seemed to have enormous power to ruin my reputation and my life. So I filed a judicial complaint with the DC Commission on Judicial Disabilities and Tenure. That's the regulatory body for DC judges who are Senate confirmed. Hired attorneys, and in the summer and fall of 2021, participated in the investigation into the now former judge. We were partway through the investigation when I found out he was on administrative leave pending an investigation into other misconduct at the time he filed the negative reference about me. But the U.S. Attorney's Office was really never alerted of the circumstances surrounding that negative reference. In January 2022, pursuant to the terms of our private settlement agreement, separate from anything the judiciary can or would do for a law clerk or former clerk, the former judge issued a clarifying statement addressing some but not all of his outrageous claims about me. But by then the damage had been done, it had been way too long, and I was pretty much blackballed from what I thought was my dream job. And my experience, as I said earlier, while not rare, is one that is rarely shared publicly. And really what keeps law clerks silent and fearful in the face of mistreatment is the fear that what happened to me will happen to them. As we discussed briefly, law clerks are not protected by Title VII of the Civil Rights Act. Folks like me cannot sue our harassers and seek damages for harms done to our lives. There are also no protections for law clerks against retaliation by judges. And much of the retaliation by judges against clerks is insidious. It is not as explicit as the kinds of negative references the former judge was submitting about me. It is when the U.S. Attorney's Office, the Public Defender's Office, the law firm calls the judge, they say, that law clerk was okay. That kind of lukewarm statement has the effect of destroying a former clerk's career. And there is really nothing to prevent judges from doing that, from making that lukewarm statement, sending that lukewarm email. And that is a question of larger cultural change in the legal community.
Mm-hmm. That's quite a story. Aliza, I know that you recently testified before the DC Council about oversight over reforms to the DC Commission on Judicial Disabilities and Tenure, the regulatory body for DC's local judges. What was that like, and what was the result of that testimony?
So the DC courts are regulated by Congress. They are Article I federal courts. The DC Council also has some oversight because DC is not a state. The regulatory body for DC judges, which is controlled by Congress as well, they are financed through the federal budget, is called the DC Commission on Judicial Disabilities and Tenure. They also consider judges for reappointment for a second 15-year term, and they basically serve as a rubber stamping function. They are notoriously unwilling to discipline judges. In their more than 52-year history, they have never disciplined, reprimanded, removed a judge for gender discrimination, harassment, or retaliation, an enormous red flag that something is wrong. The commission is led, their chair and vice chair are a current federal judge and a former local judge.
Mm-hmm.
I have been saying for a very long time that processes, procedures, statutes need to be revised, that there needs to be increased oversight over this commission, and that their notorious unwillingness to discipline judges really chills complaints by law clerks.
Mm-hmm.
I had a really trying experience with the commission after I filed my complaint. It was ultimately dismissed after a very painful set of interactions with them, in which the special counsel said things to me like, I must have done something wrong because the judge hired me in the first place. And when they dismissed my complaint at the time, I felt shame, but that really did not halt my advocacy in any way. And I think the commission and the former judge hoped that that fact that my complaint had been dismissed would silence me. It did not. I came to realize that the vast majority of law clerk complaints are dismissed and that very few were filed in the first place. So each year there is a Judiciary Committee oversight hearing for the commission, and that is where I testified a few months ago.
Mm-hmm.
I advocated for some basic and very important changes, including data dissemination, producing annual reports, which they had not done since 2018, about the outcomes of judicial misconduct complaints, procedural due process rights for law clerks. When your complaint is dismissed, you don't receive findings of fact, you can't appeal, judges can appeal. I don't think judges should lead this commission. I think there should be clear timelines for review, whole host of very basic reforms. It was very challenging. And when people testify before DC Council, testify before Congress, they don't usually come face to face with the people who dismiss their complaints. I was face to face with the two judges who I really perceive as, destroying my legal career, candidly. And they were not happy with my testimony. They made some statements. That's unfortunate. In conjunction with our testimony, mine and theirs, they did make some announcements about increasing data transparency, which is great. They are making some basic changes, which is great. But those are just the first step. I really think that this commission needs to only handle judicial reappointments. I think that the DC court should be covered under the Judicial Conduct and Disability Act. That is the federal complaint process for all Article III judges and some Article I judges. I think the DC court should be covered under that, eliminating the DC Commission's jurisdiction to mishandle judicial misconduct investigations.
Yeah, that's a very interesting point. Yeah.
That is an uphill battle, and we will see. But I think sharing my experience is important. I think advocating on this issue is important, regardless of how personally taxing it might be for me. And, judges have been generally quite supportive of my advocacy, of the Legal Accountability Project. The DC courts and the DC Commission are certainly exceptions to that. And I think that's very sad that in the face of a law clerk sharing their experience, advocating for change, that there is so much burying of heads in the sand, so much stonewalling. The DC courts have just been unwilling to engage with me for the past 13, 14 months since I began advocating on this issue. I'm not going anywhere. And LAP is just kind of growing in influence, gaining steam, advocating for increased transparency and workplace protections in the DC courts can't be the only thing I do, but it is certainly very personally important to me. And personalizing my advocacy work is important. I think it's what gets me in the door with many law schools and other stakeholders. There's never a question as to why me, why now, why is this a solution you're proposing? But it also means I take setbacks very personally. I certainly took the response from the DC Commission very personally. Nobody likes to be kind of criticized or dismissed. But then every setback with a law school where they say, everybody has a positive experience, it's our official policy not to warn students, that means a whole class of students is going to go another year without urgently needed resources. And it makes me very sad to know that what happened to me will happen to other clerks.
Yeah. I mean, you're facing enormous headwinds. I guess my last question would be, what gives you hope? Where do you see little cracks in the system that might open up into something that's more equitable and more transparent?
I love this question. A couple things. So many current and former clerks, attorneys at all stages in their careers, just random people, reach out to me every day on social media and via email to thank me and confide in me. And as I have those one-on-one conversations with current and former clerks, I see them becoming more empowered. They share their experience with me for the first time. Then they are empowered to reach out to their law school to share their experience for the first time, to advocate for change, to help protect the next generation of young attorneys against workplace mistreatment. The overall positive response from the legal community gives me a lot of hope. I think when we launched the Legal Accountability Project last June, there was probably some skepticism. Is this girl just going to be out there antagonizing the judiciary? What is this going to mean for us? I'm clearly not out there criticizing judges. I criticize judiciary leadership sometimes for their unwillingness to make reforms, but that is not personal. That is criticizing the system. And I've really honed the messaging in collaboration with some really wonderful deans and clerkship directors to bring more people in. One of the other things that gives me hope Not every law school is a willing partner right now, but some are. And there are just some wonderful deans out there with whom I am working who just got it immediately. When I first reached out to them last spring, they spent a long time on the phone with me. They knew all about what I was doing. They have been great partners through and through. They convey that I have changed the messaging and programming around clerkships on their campuses. The clerkships database solves an enormous problem in the legal community. And that is fantastic. And I think some of these wonderful administrators are going to help me lead the charge on these issues. I certainly can't do it alone, but I think the positive response has been surprising and really encouraging.
That's wonderful. That's great. If people want to get in touch with you, and we'll put this information in the transcripts as well, but what's the best way for people to reach out to you, Aliza?
So our website is legalaccountabilityproject.org. They can visit the website, join the mailing list, support us. My email is aliza.shatzman@legalaccountabilityproject.org. And I love hearing from law clerks and students and alumni who want to reach out to their administrations. I love having those conversations. And then I'm very active on social media, particularly on LinkedIn and Twitter at Aliza Shatzman, talking about these issues every single day.
That's wonderful. Thank you for doing this important work, and I really appreciate your time today.
Thank you.
Thank you for listening to On Record PR. Visit our website, onrecordpr.com, to subscribe to the show, share it with your friends on social media, find show notes, additional episodes, and more information. We'll see you next time. In the meantime, feel free to send us questions or show ideas at podcast@onrecordpr.com.